Eddy de Smijter, Lena Hornkohl, Marek Martyniszyn. Welcome to Digital Markets Research Hub. We have recorded last year a panel on this topic, and after a year, it's a nice opportunity to reconvene and to look at the development of the regulation. And I proposed the first round as just a reminder, a quick outline of the main developments, main achievements, and the overall maybe even mission of the FSR. Eddy.
Okay, Oles, hi. And also hello to Lena and Marek. Good to be back after 1 year. And indeed, a lot has happened since we last met in this forum. Maybe indeed first to remind everyone of what the objective is of the foreign subsidies regulation. It is basically an instrument that was created to ensure the level playing field on the European internal market. We want companies on our internal market to compete with one another on basis of merit. But we know that that competition can be distorted, amongst others, because states are granting aid. Now, within the European Union, we have strict rules for that, the state aid rules. However, there are also companies active on our territory that are receiving money from non-EU member states. And so far, that went uncontrolled, apart from the trade defense instruments looking into the import of subsidized goods. Companies could provide services, make investments on our territory, and that is something that we continue supporting them on, but it should be on a fair ground. And if they do that on the basis of foreign subsidies, they're not really competing on the merits. So that is what the foreign subsidy regulation is about, making sure that we can create, maintain that level playing field on the European internal market.
Thank you for having us back. It's always nice to reconvene and take stock after 1 year. Yeah, I mean, Eddy has perfectly described this. You know, we've always called on the Commission side regulatory gap, as we have state aid in the EU, but not for third country states, and all the other instruments out there, trade law, but also procurement law, competition law. They could not sufficiently cover any possible distortions by foreign subsidies, played a role in the assessment, but was not decisive. So I think the foreign subsidy regulation was needed, and it was also introduced as a pillar of the last Commission's objective on open strategic autonomy, so a policy to ensure that the EU can act autonomously when required, but work with partners when possible. So internal production capacity was promoted, but also beneficial trade relations were kept. And I think the FSR is a very great or a perfect element of this overall policy that consists of many different strategies. A stepping stone towards a more EU industry policy, assertive foreign policy, cautious geo-economic development. And I think we will for sure discuss this later, how it played out in practice.
Great, thank you, Lena. Marek.
Thank you so much for having me. It's lovely to be back, and the topic remains very relevant. What could I add to what already has been said? Clearly, this is an add-on regulation. So we have a variety of systems of law that would come to play in case of cross-border investment of diverse nature, from rules at the EU level, like FDIs, to also international trade rules. So we have more complexity when it comes to investment, and that relates to red tape, and probably we'll talk more about this. We have also trade defense mechanism in the EU, so variety really of rules. So this is an add-on, not a replacement. So we have more things to look after, not fewer. That's important. Importantly, it doesn't apply to goods. So we are looking at a situation of procurement, mergers and acquisitions, maybe some other economic situation, but not imports of goods. So this is quite important because, for example, US Inflation Reduction Act mostly applies to, relates to subsidizing goods, right? So because that's an interesting interface between EU and US as well. Because, I think that there is a perception in some parts of the world that FSR was really a law to deal with countries where you have lots of state subsidies being granted, lots of state intervention into economy, right? But of course, this is a law of general application. So it's not targeted at a given particular regime. So, let's not forget, it can apply equally to, EU's dealings with Brazil, Canada, China, whoever, right? But of course, in practice, it is more likely to come to play only in those situations where you're looking at countries that do actually actively involve in the marketplace. And perhaps I stop here.
Thank you very much, Marek. So let us move to the major developments, Eddy.
Okay. Well, a lot has happened since we last met. Let's have a look at it maybe a bit chronologically. I think the first major event of last year was when in March 2024, DG COM created a dedicated directorate to enforce the foreign subsidy regulation. Before that, we were a task force within the International Relations Unit. Now the foreign subsidy regulation is enforced by Directorate K, and we grew to 40 colleagues. So that is an important change because it means that we have more capacity to take up cases. That showed immediately after the creation of Directorate K, when in April we announced our first 2 ex officio cases. We had one in the wind energy sector by sending RFIs. And then we also in April had our first dawn raid, the first inspection against Nuctec, a company active in security scans, amongst others, where we have inspected the EU premises. As you know, Nuctec has appealed that inspection decision, and which meant that over the summer, we got the first order, the first FSR order from the President of the General Court with regard to the interim measures that Nuctec had asked for, dismissing that request for interim measures. If you wish, we can go further into that maybe a bit later, but let's stick now to a general overview of what happened last year. In June, we had the first opening of a phase 2 of an investigation, so the in-depth investigation in the Emirati Telecom case, which was a concentration case. That led in September of last year to the first commitment decision. So a lot of firsts last year. And also in July, another first, we gave our first guidance on concepts of distortion, of balancing, which will later in January 26. So I'm already inviting myself for next year's session, will lead to formal guidelines from the Commission on key concepts. So a lot has happened. I should also not forget, obviously, the notification of concentrations, which is a bit of a constant flow of work within the Directorate. We are receiving on average 7 to 8 notifications under the concentration module of the FSR. So that's a constant flow of work, but the rest, as I mentioned, were new developments worthwhile mentioning.
Thank you very much, Eddy. Just to know that when you sign up to this Digital Markets Research Hub workshops, there was a kind of small print, 5 years close, so there is no need to invite yourself. You already booked. Lena.
Yes, I think the overall developments of last year are these 3 categories. So you have the institutional one, so you have the new directorate within DG COM, but also in DG GROW, you have the procurement procedure. Then you have the regulatory and soft law updates. And here I would not only talk about the guidelines, but also, we had the FSR brief, which I think was very helpful. the Q&A document that was, is constantly updated. Of course, it was not really in the last year, but the implementing regulation still is very helpful. So also on this regulatory side, when we see the first strain of cases, or when I look as an outsider into the first strain of cases, of course, the first decision under the merger tool was very interesting, also in the sense to better understand how distortions are assessed in concentrations. And so far, it's not published yet, but we see this two-step test that you assess a distortion in the acquisition process, but also a distortion to the activities of the merged entity post-transaction. So a two-step distortion test, which is something to consider also for future cases. When we look into the procurement procedure, what I found very interesting is that there were also quite some in-depth investigations. We didn't have a decision yet, as far as I know, because all these in-depth investigations led to withdrawals from the subsidized bidders, which, as far as I see it, can anyway be seen as a victory, because you see the FSR as a tool is working, and when there could be problems with foreign subsidization in procurement procedures, then the undertakings themselves take themselves out of the race. So I think from that side also major developments. And then of course the case Eddy already mentioned, the NewTech case, where we had the first at least interim decision by the General Court, is interesting from an FSR perspective, but also from an overall, how vast does any extraterritorial nature of procedural means go? So what can you actually ask for? I mean, it's only an interim decision, but it's quite showing.
Thank you very much, Lena. Marek?
Thank you so much. Let me touch on some of the things that already were mentioned by Lena and Eddy. Clearly, we're seeing a significant interest in this area, right? I think it's fair to say that the level of engagement in relation to merger and acquisitions and procurement is significantly higher than expected. I remember the Director-General of DG.Com talking about expectations, how many people will be needed, and what he got to staff it. He was quite disappointed, and it seems that the need is even larger than it was anticipated by him a year ago. So I think the need is there. Of course, some of that may relate to the market still learning how these things are going to operate. But I think this is significant, and we had lots of firsts. That's true, but I think we are still in the stage of learning by doing, right? We still don't know how many of those things operate. Lena mentioned these two situations when foreign firms, in both cases Chinese, withdrew from the procedure as a victory. I don't think it's a victory really, because we lost an opportunity to see how these things will play out on facts. We would have to see the decisions, see how these tests were applied, right? We had the FSR brief, we had some guidance, but we have not seen a case. We don't have a decision, right? And of course, if we had the decision, there would be an opportunity perhaps for judicial review. We would hear more about the courts, what they think about the way FSR should operate. So I actually hope that this new year will bring us some more developments in terms of actual decisions, so that we know more about nitty-gritties of how this document, how this system of law operates. Because I think there is quite a bit of uncertainty, despite all the good work done by the Commission to outline what they could, but it's still new. We are still learning. So that's where we are for me. Thank you.
Thank you, Marek. I wanted also to ask about the general atmosphere, about the feedback. Obviously, we hear different stakeholders, different commentators reflecting upon the first year. Which overarching message do they convey? Is it possible to decode only one message? But if more than one, what are the main themes which we hear from the major, maybe regulatees as well?
Oles, can I first reply to what Lena and Marek said, and then I will reply to your question. Just 2 points that struck me. One, it's true, we are at the beginning of the enforcement of a new instrument. I mean, it goes without saying that we are still developing the instrument as we go. There is a decision, Lena referred to it. The only thing is that that decision is not in the public domain yet. Well, we have the opening decision of the phase 2. We have had the press release when we adopted the commitment decision in September, and we are working now with the parties on a non-confidential version of the decision. And as soon as those conversations are closed, we will readily publish the decision. But what is already clear from the press release that we have announced, and it's good that Lena underlined it, is that in the context of concentrations, we are not only looking into the effects on the acquisition process itself, but also what effects the foreign subsidy may have on the activities of the merged entity post-concentration. That's a clarification we gave already in July, and it is applied in the Emirati Telecom case in September. So that is already giving important guidance through decisions. Marek wants more decisions. I'm with you on that. Hopefully this year we will see more of that. Second point, Lena, when referring to the court order in NUCTEC, the one in August, was mentioning, I hope that I quote you correctly, Lena, you were referring to the extraterritorial effects of our instrument. I'd like to dispute that. I think what the court has said is actually the opposite. The court said, the president of the General Court said, if a company is carrying out activities on the territory of the European Union, then the Commission is entitled to investigate those activities. It cannot be that one is storing its data outside of the European Union and thereby is off the hook. I mean, that would be too easy. That would jeopardize the effective enforcement of any regulation that is aimed at a level playing field. So what the president of the General Court said was that when you have an activity in the European Union, you are submitted to European law, and you cannot avoid that application of European law by having your data store elsewhere. So I think that it showed that we are competent for what is happening within the territory of the European Union. So I dispute the term extraterritorial effect. It is within the territory of the Union.
Let us pause here, and
Okay.
because Lena and Marek will, I'm sure, I wanted to comment on this as well.
Well, what I meant with, or I just wanted to point the case to that discussion, because I didn't say that it was necessarily had extraterritorial effects in that sense. However, that in that, or concerning that decision, the question of extraterritoriality was raised. And in that instant, what I found particularly crucial, what the president said, is also procedurally that the companies must justify that the information cannot be stored in the EU. And if they are not doing that, that it would really be against public international law to not give access to this information. When I mentioned the extraterritorial nature of the FSR in that sense, I just meant that it was disputed, at least by the parties in that sense, that here the EU would go beyond its powers, which I, at least from what the president said, is not true, as you rightfully said, and leads to certain, I would say, procedural guarantees that's beneficial more for the commission enforcement, in the sense that now the company must bring forward any justification, which, you see that we're learning from past mistakes, where usually procedural issues such as burden of proof and who has to bring what forward can lead to very, very long proceedings. I mean, we know that from competition cases. And as we talk all the time about learning, and this is a work in progress, you see here that quite straightforward that we're learning from these mistakes, that first you have to tackle these procedural issues before even talking about any substance.
Thank you, Lena. Marek?
Thank you so much. I live and breathe extraterritoriality, so let me also add a thought on this. I do think that regulation contains a number of clauses where Commission claims a variety of extraterritorial powers, especially the issue of the opportunity of conducting inspections outside the EU, conducting interviews outside the EU. We haven't seen that done, right? So, we often have that in law, that sometimes authorities say one thing and that doesn't necessarily reflect the what's available or possible for them under international law, and that is not being done. And we haven't seen anything of this type that controversial so far. So this is perhaps yet to come, if at all.
And now please comment if you want, and then revert to the next question. If possible.
Yeah, very briefly on what Marek said. On the TDI, there is also the possibility to go abroad on a verifying mission. And in TDI and in an FSR, we do that with the consent of the third state. So it's not that the Commission is imposing extraterritorially its powers. If we are an unwelcome guest abroad, then we will take note of that. But that sovereignty is always respected. And I think that Lena, on the point that she raised, I think that she indeed clarified what the President said, and I'm happy to see that we are on the same page for that. Shall I come to your initial question then, Oleś? Very briefly, what I've seen, particularly with regard to the notifications and concentrations, is that the quality of the initial draft of the form FSCO that we are receiving in pre-notification stage, those initial drafts became much better. And that is probably because companies, and particularly their legal representatives, know what we are after. They know the kind of questions that we are asking. And so you see that those questions are being preempted already in the first draft of the form that we are getting, making the pre-notification phase shorter over time. We have seen good quality first drafts where we only need to have one, maybe two rounds of RFIs to get into the nitty-gritty of particular foreign financial contributions. So that's for me a clear sign that for sure the legal community, and hopefully also the business community, has understood what the FSR is about and knows how to deal with that. I think that is a positive development.
Eddy, can you update us on the numbers or some data about how many of such notifications you receive, if it's possible?
I can. Let me open. I knew that question was going to come, so let me see where I had that. Just a second. I think. You may wonder, well, trying to operate my mobile phone and my email at the same time. So far, we have received 117 notifications. As I said, that is an average of 7 to 8 notifications in concentrations per month. For the moment, we have 33 cases in pre-notification phase. And of the 117 notifications that I just mentioned, we have closed 100 cases. So 17 are still in the notification phase. I don't know whether that's helpful. It's a bit of a constant flow. That means that if we get additional resources, which we hope for, and which we were happy to see also Mr. Draghi being supportive of, that will mainly have an effect on our ex officio investigations, because the concentration flow is rather stable.
And in your gut feeling, does it reflect the amount of those who are required to notify? How many do we have under radar, so to say?
Yeah, we are monitoring the market to see whether, well, two purposes of that monitoring, at least two. One is indeed to see whether notifiable concentrations would not be notified. We don't have that impression. Also because the major part of the FSR notified concentrations are also notified under the EUMR. It happens occasionally, but less and less, that the merger colleagues need to, because in the merger form you also have to indicate whether it's FSR notifiable or not, that merger colleagues need to ask the parties whether they haven't forgotten about the FSR, but we hardly have any of those cases left. We're also monitoring the market to see whether there are below threshold concentrations that are worthwhile calling in. And so far, none of those concentrations have been called in. So we do monitoring in order to ensure that the obligations of the FSR are respected, but also whether we can, whether there is a good opportunity to use the exceptional power that we got from the co-legislator to call in concentrations that are below the notification thresholds.
Excellent. Thank you very much, Lena.
Well, I would say from business sides, I think in the beginning there was a lot of uncertainty and concern about administrative burden, but from what I hear, specifically because of the Commission guidance, all these guiding documents, but also bilateral and pre-notification talks, some of the concerns have for sure been mitigated. When I talk to people from the business sides, they still say that, of course, FSR compliance imposes a burden on internal resources, specifically when it comes to identifying foreign contributions at the very entity level. So especially in big group companies active worldwide, what they say is, given the broad scope of notification requirements and the information required, usually that's not covered by any standard accounting or any reporting systems in place. So what is really needed and what everybody is stressing is you need to have a specific dedicated reporting system for foreign contributions, and that places some burden on large holdings, large corporations. And what some are at least mentioning is that the fact that we have the FSR pushes EU companies to sometimes favor deals with less lucrative partners because there's a greater regulatory risk with this deal. So it has an impact on the business side without even reaching any case level. So without even coming to a concentration or procurement case in the end. And there, Marek and I, we can debate about, what's a victory or what's not a victory. Of course, from a purely academic side or also legal certainty side, of course, it would be nice to have more cases published. But if you look at the objective of the FSR, so for example, we want less foreign subsidized companies active in merger cases. If you see from when businesses tell you we do not make deals anymore when there is a greater regulatory risk, at least from the objective side of the FSR, it seems to be working.
Thank you, Lena. Marek?
Thank you so much. Let me then go back to this idea of victory. The challenge, of course, is that EU wants to be open for investment, right? And the challenge whenever we introduce any sort of a new type of rule that is unfamiliar is that legitimate business may disappear or may not happen, may not come to, the investment may not come to the EU just because of the uncertainty, right? Just because they'll be discouraged, right? And that's what happened in these two procurement cases, because we had this decision that Eddy mentioned, but that was in mergers and acquisitions. We didn't have a decision in procurement, right? And I understand that procurement is run by DG Growth, not competition. So that's also quite interesting, right? Because we have slightly different mindsets in both DGs, right? By design of the DGs. And the issue is whether we can achieve the aims that were put forward without discouraging the sort of investment that would be very beneficial to our economy, right? And that's the challenge. Now, going back to the question of burden, I think that Lena stressed that very nicely. Allow me just to underline this. Why FSR can be seen as a problematic tool in terms of burdens is that simply we're asking for information that firms have not been collecting, right? They just are not used to collecting this sort of information. So this is a new ask, right? And as Lena correctly pointed out, when you're looking at big conglomerates, and again, allow us to remind that this piece of law is to apply only to very big deals, right? The previous commissioner talked about catching the big fish, right? So we're looking at very complex business structures, organized in very different ways, operating often at different markets. So this is, from the practical perspective, it must be troublesome. There's no doubt about that, right? And learning how to do this, is just the year since it started being around us, right? I think the practice must be, by definition, still learning. So I don't think that's anything unusual. Thank you.
Thank you very much. Does anybody of you want to reflect on the issues?
Can I don't know, Lena, whether you want to come in? No, otherwise.
Yeah, go on, please.
No, go ahead.
Yeah, okay. First, let me underline what Marek said. The European Union is and wants to remain being a space where investment, foreign investment included, is welcomed. There is a new instrument. We try to give as much clarity on what it is about and how we are enforcing it. I would hope very much that legitimate investment, as Marek calls it, is not scared off by the fact that we are having the instrument. If ever there is a question, I think it is crystal clear that we can always be contacted. And we are being contacted. And we are responsive to any request for further information. That can be in the context of a concentration, but not necessarily only in that context. So we are a responsive administration. Whenever a potential investor has a question about the FSR, just give us a call, send us an email. I think that contact details are well known. A new instrument, like the foreign subsidy regulation, is leading indeed to new obligations. Does that equal red tape? Not in my definition of red tape. Red tape is unnecessary administrative burden. What we have tried to do, amongst others with the implementing regulation, is to make the additional obligations, and those are unavoidable if you want to achieve a certain objective, is to make those additional obligations proportional proportional to the request. That was the objective of the implementing regulation. Of course, it's a challenge. I will not ignore that. It's a challenge, particularly for big companies. But what we saw over the last year is that also these big conglomerates know about the FSR, they have informed themselves well, and are preparing even before pre-notification stage. I can assure you that there are very big companies involved as an acquiring entity in our concentration cases, and they have the possibility to submit the form with the foreign financial contributions included, because they have prepared well. That is the crux of the matter. You know that the obligation is there. Don't let yourself be surprised. Prepare for it. The tools may not have been available in 22 for the accounting tools that Lena was referring to. The regulation is there. It's not going to disappear any moment soon. So get yourself prepared. That is what matters. One final point, if I may. It's true that DG GROW, the colleagues from DG GROW are responsible for the enforcement of the public procurement bit of the foreign subsidy regulation. That's with them because of their specific expertise with regard to public procurement. We are talking to each other every day in order exactly to achieve what Marek referred to, that we have a homogeneous application of the law. And because the market is entitled to that uniformity of the application. So when we are applying the same concepts, we are applying them in the same way. And in order to ensure that, we have back and forth on a daily basis.
Thank you very much, Eddy. I propose to change the order now for the next question, which is kind of broader, not societal, geo-economic implication. We don't function in the bubble, and we understand that the global trade is so turbulent these days. I wanted to ask maybe to reflect upon the jurisdictions which are affected most by this mechanism, by the regulation, and also how flexible and adaptable it is and should be, and responsive to the development in the international landscape. Marek.
Thank you so much. Indeed, this regulation sort of by definition sits on the interface of law and politics, right? Because it does affect trade. And I think there was and continues to be a perception, especially in China, that it is an anti-Chinese law, right? And the two cases in procurement that we've withdrawn all concerned Chinese firms, and these were all state-owned enterprises. It's quite significant. But it's not, again, it is law of general application, right? And will apply to players from different parts of the world. You can think about parts of the world when you have huge sovereign wealth funds. That law will apply to them as well, right? And we've seen this decision in merger and acquisition, which involve a firm not from China, which is quite important. The Chinese case is important because, of course, China is second largest economy in the world, the biggest exporting firm, the biggest exporting country. And indeed, I think that there is tension coming from China that is being, I think, leveraged now beyond competition law as such, right? In last year, one of the chambers of commerce in China complained to the Ministry of Commerce that FSR is being applied in a discriminatory manner. And actually, at the start of January, we had a decision, the final conclusions of an investigation by the Chinese Ministry of Commerce in relation to FSR. And they actually, their investigation found that it does constitute a barrier to trade. And I think this is significant. That's the official position of the Chinese Ministry of Commerce. What does it mean in practical terms? In past, I understand that similar investigations led to introduction of extra duties by China on imports from the EU. that I think related to alcohol and some of food products. This, of course, in theory, could lead further down the line to a case in World Trade Organization. That need not to happen. I would see it more as a pressure put on Europe to discuss FSR more broadly. What I find quite interesting is that I actually read that final report from the Chinese investigation. That's a robot translation, so may not be, and unfortunately don't speak Chinese, at least yet. What I found quite interesting is that Chinese Ministry of Commerce reached out through our US delegation to China with a variety of questionnaires, and they argued that these questionnaires were not answered. They argued there was no engagement, right? And that element, I'm not sure whether it's true or not, and perhaps something got lost in translation. But that element I found surprising. As you would expect, most of the Chinese firms that were surveyed for the sake of this investigation argued that they basically don't understand how this regulation operates, right? That clarity and transparency is missing. It may be simply that we don't have enough yet practice, right? Maybe we are still in this learning by doing phase. I fully agree with Eddy that these rules are not going anywhere. So it's time to take it seriously and learn and in a collaborative way, find ways in which business can continue smoothly. And I will stop here. Thank you.
Thank you, Marek. Lena?
Well, what can I add? I mean, of course, and Eddy has said that earlier, the regulations of general application, and for sure, Eddy can tell us more where most of the notifications are coming from, or where most of the foreign subsidies that discussed in the cases are coming from what is public or in the last year. All but one of the in-depth or ex officio investigation have targeted Chinese companies. We have also, of course, the state-owned enterprise from the Gulf states. So I wouldn't say that the regulation is aimed at China, but from practice, at least from the first year, what we see in the public is that Chinese companies are particularly targeted, but that also means that not necessarily that the FSR is only directed at these specific states, but that there's maybe less international cooperation, because we also know from the regulation that if you have international agreements, international trade agreements with the European Union, that these can take precedence over the FSR enforcement mechanisms. And here, I think we come back to this open strategic autonomy objective or behind the whole regulation. If you work well together as a trading partner, then also in terms of FSR, this is reflected. If there's no or very little international cooperation, then this reflects in the case practice. Outside of maybe jurisdiction, I think what is very interesting to see from the cases that are public is also the business sectors that the cases stem from. So we have 8 strategic sectors from, rail, telecoms, energy, security. So all areas that are quite strategic to member states and the union altogether. So I would not only focus on this jurisdictional aspect because it's just the very nature of international cooperation that's out there. I would also look specifically into the areas of sectors that are really crucial for our industry and for living well together in the European Union, not making us dependent on foreign influences. So I think that is more interesting to me, because as we will see an enforcement over the years of the FSR, I'm sure we will not only have a very one-sided jurisdictional view, because with everything that's changing in the world right now, and the FSR in its wording is as it is, we can have very different cases quite soon.
Thank you very much, Lena. Eddy.
What can I add? I think that Marek said it quite rightly. The FSR is country neutral. It's of generally a general application. There is also within the FSR team, there is no instruction or inclination to go after a particular third country. So we're very neutral in the investigations that we are carrying out. I also am very much convinced that the FSR is WTO compatible. And we would hope that any action by a third state will similarly be WTO compatible. Voilà, I think there's little else to add.
Okay, Marek, if you want to comment on what has been said by Lena and Eddy, and also I have another question, namely how to streamline the process. It's still work in progress, as has been said. We are talking about draft guidelines on FSR, implementing regulation. We have also quite rich Q&A section, and maybe other ways to fine-tune the compliance. Marek, please.
Thank you so much. Allow me to touch on the issue of compatibility with World Trade Organization law. I think that's a very good point. And I think from academic perspective, it would be good to distinguish between the rules themselves and their application. I don't think there is any problem at all when it comes to rules themselves, right? What can be perceived as problematic is the way rules are applied. And this really leads us nicely into the issue what can be done going forward. And this is really to continue for the Commission with good work of explaining how balancing test is applied, what sort of information will be required, be more sensitive to, or continue being sensitive when it comes to, parties' requests for, extending some of the deadlines. I think, market is still learning how it operates. Even good law firms are still learning how it operates. So I think some compassion in this process would be welcome.
I think the way forward, I can, of course, say we want more guidance, but I don't need to say that even because I'm very sure that this year will bring us more guidance. We will have the publication of the first concentration decision. We will have more cases, and so I know that the legal certainty and the guidance will come. So there's no need for me to wish for that, and we know from the regulation itself that there's this deadline for further guidance even in the text. So when we talk in 1 year, I'm very positive that there will be more guidance. What I think the future will bring is with everything that's generally going on within the new Commission in the EU. We have the Draghi, the letter report. We have now this week coming up this European Competitiveness Compass. I think the FSR will play a crucial part in that sense, in a stepping stone towards more Europeanization of industrial policies, less foreign influence. And here, I want to come back to this legitimate investments that Eddy mentioned earlier. When you are a legitimate trading partner, when you have a legitimate investment, we still stay open as a market in Europe. However, I think Europe needs to be more autonomous, needs to involve more European industry where this is necessary. And if a deal maybe is not been conducting with them, maybe less reliable foreign partner where there's greater regulatory risk, then this might turn back to European industry. And with everything that's happening in the world, in the US, particularly, you can never be sure of former statements, and you have to a little bit rely on yourself. And I think that's what we will see in the next year with the new commissioner, with the new plans in place, and the FSR is one key part of this. And for that, I'm very excited to see the developments.
Thank you, Lena. Eddy.
Well, I take the wish from Lena and Marek for more guidance. I take that at heart. It is important. I fully agree. We do give clarification through our enforcement actions. But Lena and Marek also refer to other means for clarification. We hope that this year we will be able to publish a second FSR brief, maybe also in addition to our Q&As, although I have to say that we are getting less questions than previously. But if there are questions that are valid for a broader community, then we are happy to turn that into a Q&A. And we have the guidelines that are promised for January 26. So in the course of this year, you will all be invited to contribute to that. What is it? What kind of guidance is it that you expect from us? So there will be an open call for interest, for contributing to the guidelines that we need to publish by January next year. So I think guidance will be key also for the upcoming year.
Thank you very much, Eddy. If anybody has any specific issue to mention before asking for recommendation to students, maybe now is opportunity. Okay, then, okay, we have the tradition with finishing by inviting the guests to provide recommendation to students. Lena, perhaps we can start with you.
Yeah, well, as I said last year, and as Marek also mentioned, the FSR I think is an interesting objective for studying, for writing a PhD, for going deeper into these matters, because as academics, as students, being on the first stage of that is kind of your job. You can help with making things more clearer. And in that sense, I would say pick the FSR as a subject of research also. We together can make this instrument work better in that sense.
Thank you very much.
Thank you so much. In terms of recommendation for students, what can I say? International economic law remains extremely interesting. FSR is an example of this. It's a system of rules operating on the interface between a variety of systems. It's not easy to work it out. This creates amazing opportunities for students, also in terms of career development and employment. And come to my university, we have a great LL.M that we focus all on these issues. Thank you so much.
What can I say, Oleg? We got publicity by both Lena and Marek for the FSR. I can only confirm. It's a super interesting new instrument. I still qualify it as new. It's at the crossroads of merger control, state aid control, trade policy, a bit of antitrust. So very interesting. I stimulate you indeed, as Marek and Lena said, to study it, to do research, to do a PhD. But after that, come to the Commission, either as a trainee or as a colleague in the enforcement of FSR. We'll be welcoming you in Brussels.
Eddy de Smijter, Lena Hornkohl, Marek Martyniszyn, thank you very much indeed for this fascinating conversation. It was a pleasure to see you today.
Thank you.